yourselves when you speak.
I will introduce myself now. I am Brandon Zhang. Together with my co-counsel, we represent the appellant, Mr. Antonio Fortuna.
And co-counsel,
My name is Mark Maxwell Peter, Prof.
could you say that again?
Mark Maxwell Peter.
And who's representing the respondents?
And for the respondent, my name is Seah, and I'll be addressing the first two issues on appeal, and I'm joined by my co-counsel, Mr. Ramesh Kanna, who will address the remaining two issues on appeal. We split the time of 10 minutes each, and we reserve 1 minute for our rebuttal.
Since we have no timekeeper today, do we have a timekeeper?
Yes, Prof. I'll be keeping the
So
time.
you will be keeping time.
Yes.
Right, when you're ready, first speaker for the applicant. Okay.
Good morning, Prof. Liu. My name is Brandon, and with my co-counsel, Mark, we represent the appellant. The appellant, Mr. Antonio Fortuna, is the goalkeeper of the Iridonia men's national football team. During a qualifier match, the appellant's team lost 0-3, and as a result, there began investigations and allegations of match fixing. The appellant was asked to provide his mobile phone, and he refused, and as a result, the respondent, FIFA, imposed a 5-year sanction with a $100,000 Swiss franc fine. Prof. Liu, the appellant has devoted his entire life to the game of football. A late bloomer by reputation, he trained relentlessly to earn the honor of representing Iridonia in his 2026 FIFA World Cup qualifier, a moment of immense national pride. He stands before this tribunal seeking nothing more than fairness. I now turn to the first submission. We submit that the statement of appeal is admissible for two reasons. First, the challenge decision with grounds is the day of receipt, and second, the appeal was late due to an IT cyber attack, which my client had no control over. And we have submitted Exhibit 8, which proves the statement of appeal was filed on time. Turning to the first argument.
When you say filed on time, what do you mean?
It has been filed within the 21-day time limit set out in Article 50, subsection 1 of the FIFA procedural rules.
So what is the dispute about? Why is this even a contentious point?
The respondent argues the day of receipt is 31st March 2026. We submit that the day of receipt is 2nd April 2026 because it is the day that the challenge decision was sent to the party with grounds, and this is at page 5, paragraph 26 of the record. In our legal authority number 1, in the 2016 cast decision of Ivan Bellotto Palacios versus PFC CSKA Sofia, at paragraph 75,
Sorry, what are you referring to now?
I'm referring to a court of sport arbitration case.
Right. Is that in our? Has that been provided or not?
Apologies, Prof, it has not been provided. The cast panel in that case held at paragraph 75 that the day of receipt was the day where the parties received decision with full grounds, and therefore.
So the day of receipt of what? I think you need to contextualize this a bit more for me. The question is when the time starts to run. Is that what the parties are disputing?
Yes, correct.
Right. So you are arguing for a later date. They are arguing for an earlier date.
Yes,
Okay,
correct.
thanks. You should tell us this to help make it easier to understand. Yes.
Yes.
Go on. And the case said what?
And in that case, they held that the day of receipt was the day where decision with grounds was sent to the parties. And here in the present case.
But why?
Yes. The reason is because without knowing the detailed reasoning, it is impossible to identify the considerations that were relevant to the breach and the criteria used in the determination of the sanction. And it allows the applicant to analyze how the judge reached their decision and whether they applied the law correctly. And therefore, we submit that it is the day with full grounds. Turning to the second argument, The statement of appeal was not
But
received.
I must ask, your client's appeal is on the basis of just legal disputes or characterizations of the facts as well? What is the essence of the dispute?
It is a legal dispute on the duty to cooperate as well as match fixing.
So I'm just wondering, in general, is it really necessary for a player to know the full grounds? I mean, the player will know what arguments were ventilated and have a rough sense of what they are being punished for. Do they need to know the full grounds to know that if they believe they didn't commit the offense, they're going to appeal it?
We argue that yes, because we must know the relevant criteria used and the detailed reasoning. And we find support from this in Article 15, subsection 2 and 4 of the FIFA procedural rules, which deems that notification to a party is only complete when it is sent with decision with grounds where it contains a sanction on an athlete. For the purposes of our case.
So what is the controversy here? This is one of the issues on the agenda. Is the respondent frivolously contesting this?
Yes, and we argue that this prejudices my client to a fair trial.
Okay, so what do you think they're going to argue on issue A?
They will argue that the day of receipt will begin on March 31st.
Yes, I know, but what argument do you think they'll offer to support that?
They will argue that it is to be a strict deadline to follow. And we see no reasoning why the panel should not allow the dispute. For example, in the case that I had previously mentioned, the panel did allow the statement of appeal and held that it was admissible and that the day of receipt was the day with full grounds. The cyber attack in the CAS decision, the cyber attack was not within control of my client.
What's the cyber attack got to do with this again? Sorry.
In the dispute here, there's a cyber attack which prevented the email. The statement of appeal was filed through an email, and due to an unforeseeable cyber attack, it prevented the email from being sent out, the appeal from being sent out to the CAS.
Sorry, meaning it wasn't sent out or wasn't received?
It was not received by CAS due to the
So
cyber
it was
attack.
sent from your clients?
Yes, correct. Yes.
It was the problem was on the recipient side.
The problem was not the recipient, but it was a cyber attack, and we have
The problem was that the cyber attack prevented it from
being.
What was the cyber attack on the respondent system? Was it? What?
It's not on the facts, but it's just stated that there was a cyber attack, and there's evidence.
On what? Okay, direct us to the record.
The page 5, paragraph 31. And here the statement of appeal was filed specifically.
No, I want you to 31 or 30? You don't want 30, right?
Page 31, page 5, paragraph 31.
Okay, so it was a cyber attack on the appellant's law firm's IT provider, right? That's what I was asking about. Meaning this was never sent out. It was not sent out till later, right?
Yes.
That could be important, because if it had been successfully sent out from your client's system or your client's legal team systems to the other side, and the cyber attack was on their side, then you'd have a stronger case. But here, it's like saying that you had already prepared the letter, but your client's dog ate the letter, so it's not his fault the letter didn't go out. How is this excuse?
Yes, Prof. Liu. In the 2013 CAS decision of AC Siena SPA versus Club Desportivo Nacional at paragraph 39, the statement of appeal was filed 1 day later. And however, the panel held that the statement of appeal was admissible because the appellant had produced evidence in the form of a shipment waybill to show that
shows that that they had successfully sent it off, but something went awry along the way. So you've got the way bill, that means you've handed it over to the shipper, right? And then the shipper has failed to do it. But here, it never left your client's system.
Yes, and this was due to a cyber attack that my client had no control over. And similarly to the case I referenced, the Italian courier picked up the receipt
But you
on
see,
that
that's the
day.
thing, the courier picked it up. So usually when you're talking about post, okay, I don't know Italian law or whatever it is, but in English and common law systems, the traditional rule has been postal acceptance for contracts at least. So when you hand it over to the carrier, you are considered to have sent it. So in the example you just cited, it was handed over to the courier. The analogy here would be if the courier never showed up. And would that be enough?
We argue that it should be admissible. First, we had no control over the cyber
I
attack.
understand, but look, imagine this. You want to post a letter. Let's say you live in some rural place. The postman is supposed to come and collect your letters. On this day, the postman is sick and doesn't come. Does it still count? I mean, would we say, oh, it's as if you posted it on that day because the postman was supposed to...
Yes, we have submitted evidence to show that we have filed email L
Yeah,
at
but you're
23.
not listening to me. My point is, in that scenario, does that make sense? If I say, well, I would have sent the letter if the postman had showed up. The postman didn't show up, so it should be deemed that I sent the letter on that day. Is that how things work outside of the email context?
We have
If I say that I was going to come and arbitrate this round, but the bus broke down, so it's as if I arbitrated the round, we wouldn't say that, right? At most, we would say, well, I have some excuse for being late, not that I wasn't late.
Yes, Prof. We alternatively submit that that it should be excused as there was no control over the cyber attack. And however, we also
Okay, so
sent...
what are the principles that guide our discretion to extend timelines? Is there discretion, or is it once you're late, you're late?
We can request for additional time. If Prof would allow me an extra few minutes, 3 minutes, I will move on to submission 2.
No, well, first I want to know what the position is here. So the court has a discretion to allow an appeal to be filed out of time.
Yes.
Where do we find this in the rules?
There's no provision that or rule article that allows for it. It is up to the discretion of the panel.
Where do I find this discretion? If there's no rule that expressly provides it, I suppose there must be some source for a residual discretion.
There's a principle called lex sportiva, which is the law of the sports. And in the CAS decisions, it is not stare decisis, so there's no binding authority. And the sole arbitrator or prof has the discretion.
Okay, thank you. You may have a minute to summarize your remaining issues.
Turning now to the second submission, we argue that there has been a breach of Article 6, subsection 1 of the European Court of Human Rights, as well as Article 8 of the Convention, the right to privacy. There is European Court of Cases which has specified that Article 6 is applicable upon CAS decisions, and there are cases which have held that there was violation of Article 6 and 8 for the refusal to cooperate and to produce evidence, as is in the present case, the appellant was sanctioned for his refusal to provide a mobile phone.
But why was he asked to hand over the mobile phone?
He was asked to hand over the mobile phone so that by the respondent FIFA, so that they could investigate the phone.
Yeah, because the allegation was what, match fixing?
Yes, correct.
So if he doesn't hand over his phone, how are they going to determine if he committed the offense or not?
And we argue that there was in fact a breach of Article 6, the right to a fair trial, because without...
That's not my point. My question is, if the allegation someone is guilty of match fixing, then how do you detect that? You look at communication between them and other people, right?
Yes.
So isn't it legitimate to want to see those communications to either confirm his guilt or exonerate him?
Yes, Prof. However, the evidence on the phone, as well as the evidence on the record, is of circumstantial nature, and communications on the phone may
No, it
also.
wouldn't be circumstantial. I don't understand that. Evidence is not necessarily of circumstantial nature. If you were to hand over his phone and they find a text saying, okay, I have sent the money to your account in exchange for you fixing the match. Obviously, people are not so stupid, but that would not be circumstantial evidence. That would be direct evidence, right? So surely the contents of his communications would be highly relevant to proving his innocence or guilt. So what's wrong with them asking for his phone?
It would be, because this violates the right to self-incrimination under Article 6, subsection 1. The appellant has a right not to be coerced into producing
So Article
evidence
6, subsection 1 of what?
of the European Court of Human Rights Convention. And apologies, we don't have our current bundle of stories.
This is sports disciplinary issue, right?
Yes.
It's like so does that apply?
Yes. Yes, Prof. This panel has observed and held that Article 6, subsection 1 is applicable because as a contracting party to the ECHR, it must ensure that its judges provide a fair proceeding. That was the case in the 2000 and in the Adamu versus FIFA case in the 2011 decision, where it was held that ECR is indirectly applicable.
Thanks.
Unless there are no further questions, this concludes my submissions. And now my co-counsel will address the merits.
Okay, thank you. Will the arbitrators have this in real life?
Oh, yes. Good morning, Prof. Liu. Good morning, members of the panel. My name is Mark, and I'll be speaking for 10 minutes, and I'll be reserving 1 minute for rebuttal. I appear on behalf of Mr. Antonio Fortuna. On issue C, I will make 3 submissions. Now, before I move on to make the 3 submissions, I will explain the issue. The issue C here is, do the anonymous evidence and anonymous witness statements constitute as admissible evidence? And we would like to submit that it does not. Because first, the CAS applies a strict safeguard to anonymous evidence. And second, those safeguards are not met with the witness and the email evidence. And third, without them, it cannot reach a comfortable satisfaction. The CAS starts from a position of distrust when it comes to anonymous evidence. In the 2019 CAS case of Karamuddin, the panel made it clear that anonymous evidence is exceptional and it is not normal. It is only tolerated when 4 safeguards exist, such as necessity, verification of identity by the panel, the ability to test
Verification by what? By whom?
verification of the identity of the witness by the panel of arbitrators, the ability to test the evidence through protective cross-examination and corroboration. And those safeguards exist to protect one thing, which is fairness, which we cannot see in this case. The witness, which we cannot see in the case, because the witness is not coming up to display or getting himself cross-examined. So now, when we look at the witness itself, we see that the witness says they are afraid because Mr. Luke Fortuna, who is Mr. Antonio Fortuna's father, has mafia or criminal ties, and at Karamuddin, at paragraph 145, it was justified that the objective third party confirmed a real risk, which is a co-witness, had been granted asylum.
Actually, the facts seem even more favorable for you than you make it sound, because even the anonymous witness does not assert that Mr. Luke Fortuna is in a criminal organization. He just says that there are rumors.
There are rumors, yes,
So
Professor.
this is like second or third hand hearsay.
Yes, Professor. So we are trying to put forward an argument that Mr. Luke Fortuna, the witness claims that Luke Fortuna is a part of the mafia, and that is the sole reason why he cannot show his face to the tribunal due to the fears of being under threat by the mafia itself. But we are exactly trying to put forward an argument that Mr. Luke Fortuna It is without, the fear is without substance. We do not know whether if he's really a part of the mafia or not.
Yes, but now here's where I wonder if you're going overboard. We can't assert that they are without substance. The point is that we can't know
Exactly.
how likely, how probable the fears are.
Yes,
There might be substance, there might not be, but
Yes, Professor.
evidentially,
Evidentially, yes, Professor. There are not. There's no. There are no chain or links which really clarify that Mr. Luke Fortuna is a part of mafia.
other than the witness statement itself, is there anything else on the probability of Mr. Luke Fortuna's membership in a criminal organization?
Professor, we are not.
Nothing else in the record?
Nothing else in the record, but we're not contesting the fact that Mr. Luke Fortuna may or may not have ties to the criminal organization.
Do we consider the probative value of the evidence at all?
Yes and no at the same time. So,
Okay.
so while we are trying to put forward an argument that the
Explain first what you mean by yes and no at the
So,
same time.
when you say the probative value of the evidence itself, when I say the probative value of the evidence is yes and no, it means that while the evidence may be true that Mr. Fortuna
No, what I
has,
mean is when we decide the question of admissibility, do we consider its probative value, or do we ignore the probative value and just look at credibility in isolation?
we look at the credibility of the evidence itself, but what we are trying to say here is that
Do you have any authority to guide us on this?
No, Mr. No, Prof. On
So-
this specific note, I will not have any authority.
Well, it's not a very specific point, it's quite a general point, because most legal systems have some approach to determining admissibility. Sometimes it's a bright line rule, it's in or out. Sometimes you just say it's all in, it becomes a matter of weight. Sometimes you say you weigh the prejudice of admitting the evidence against the probative value of the evidence. There must be some approach to guide this tribunal.
Right, Professor. So, the reason why we do not want, I would like to retract what I said earlier, and I would like to submit that we do not want this evidence to be submitted, or even
I
if
know
it's
you don't want it.
submitted,
So what are you saying would be the correct approach for me to adopt?
the correct approach for Mr. Arbitrator to adopt in this situation would be that we give no value to this evidence itself.
No value. So I
No-
admit it, but I say it's got zero weight.
Yes, Professor.
Is that the same as excluding it?
Yes, Professor. We would, because
Well, the effect you're saying would be on the decision.
it would not carry
Procedurally,
any
does the
effect.
difference? Does the difference matter? Because procedurally, there's a difference between saying I admit the evidence, but I will give it less weight or maybe even zero weight,
Right.
because then it's still part of the evidence. Versus saying I exclude it, I must pretend it doesn't even exist. Does it make a difference? And which is the approach that most tribunals take?
At the court of arbitration, it depends on the arbitrators
It's
itself, whether
discretionary.
on it's discretionary. But if in a scenario where the arbitrator, such as yourself, were to accept and admit this evidence, we would like to submit that it should not be given any weight or value.
Okay, well, one thing that strikes me about this evidence is that it doesn't seem, arguably it's not even that helpful, because it's just about a conversation with his father,
Yes.
where his
Yes,
father
Professor.
wanted one thing and he disagreed, and we have no idea what the disagreement was about.
Correct. Exactly, Professor. Because we have no idea what was going on the other side of the conversation. We only hear from the witness that that Mr. Fortuna was talking over the phone and having a conversation, and he explicitly was saying that I do not want to be pressured.
So here's where I wonder if your client's own conduct has some bearing on this, because if there's always uncertainty, well, what would help dispel the uncertainty? One thing would have been if your client had been cooperative. Then it would be possible, for instance, to look at his text exchanges with his father,
Mm-hmm.
and if they were about some unrelated matter, the text messages would show that.
Right.
So, since your client has decided not to cooperate, and assuming I'm with your client on issue B, not to say that I am, would it not at least be fair to say, well, if he's entitled to withhold this, then at least we should have recourse to the next best available evidence, and that would seem to be this. It may not be much, but it's all we have to go on.
right, Professor? But as my co-counsel mentioned, that there was already a criminal case going on at that point in time against his father regarding the 50,000.
Where's that?
Professor, we would like you to refer to page 3, paragraph 11 of the record.
Okay.
So here we see that Mr. Luke Fortuna is being investigated by the public prosecutors of Iridonia for the transfer of 50,000 Doge coins, which is equivalent to 50,000 Swiss francs, Swiss dollars. This is during the lead up of the match itself. So in order to not implicate himself, Mr. Fortuna's lawyer asked him not to submit the phone
see.
itself.
So could I ask, might it be that all of this was a little bit premature? Because there was an ongoing criminal investigation that would surely unearth relevant information to this case.
Yes, Professor. As we see on paragraph 4 of the Exhibit 5, paragraph 4, we also see that it was only under investigation. There was no guilt found. The Iridonian prosecutors are only currently at this point in time assessing the situation, and they're not holding Mr. Luke Fortuna accountable or.
So wouldn't it have been more prudent to stay the disciplinary proceedings until more evidence became available?
Yes, Professor. It would have been more prudent, but while this whole fiasco began, Mr. Luke Fortuna wanted to be careful, and he wanted to take one step further to make sure that he does not implicate with his father. We are trying to say here is that the father may be doing things behind his back, but Mr. Fortuna is not part of that whole situation which his father is doing.
But that's a little bit inconsistent with your justification for your client not wanting to get over his phone. Because if it's true that his father was doing stuff behind his back, then why would the phone records implicate anyone?
Because initially the anonymous witness statement itself states that there was a conversation going on between the father and Mr. Fortuna. So naturally, using that set of evidence, it is easy to infer that Mr. Fortuna was a part of this whole system, which was manipulation of the match before the competition itself.
So is the concern that it might prejudice his father's investigation, or that it might prejudice
his investigation,
own...
Professor?
Okay, so you're not saying that the reason he didn't cooperate was because he didn't want to get his father in trouble? That's not what you're saying?
Yes.
Okay.
We are saying that he did not want to get himself into trouble because he wanted to keep himself separate away from his father's situation.
I see, okay.
So, Professor, I understand that my time has elapsed. If I can have 2 more minutes to wrap up my issue D.
I think just 1 minute
Sure.
to deal with. I'd like to hear your brief case on Article 20 of the Code.
Sure, Professor. So for issue D, the issue D, concerns regarding whether if my client violated Article 20 of the FIFA disciplinary code. So first, we would like to submit that the match fixing requires convergence, which is intent, planning, money, and coordination. This is entirely absent in this case because the Genius report itself expressly states that the three goals which were made, were not all Mr. Fortuna's fault. Yes, we completely accept that the first goal was made due to his own error, but the second goal at 64 minutes and 4 seconds was a result of no individual error but rather a teammate's error, and the third goal at 88 minutes 13 seconds was a result from his teammate's hamstring injury. So we are trying to, and we also see no no corroboration. We also see We also see no
Right,
plan.
so the second and third instances really had nothing to do with him. Well, I mean, he's the goalkeeper.
He's the
But
goalkeeper.
it was not his error.
It was not his error. We also would like to submit that Mr. Fortuna is not a skilled player. He was a seat warmer until the main goalkeeper of the team itself couldn't perform, and he had to step in. And and his poor performance was under due to pressure as well, and also from being sick.
Okay, but sorry, that is if we only look at the goals, right?
Yes,
What
Professor.
about the other passages of interest?
The other passage of
Quite a few of them, or
Right.
at least two of them
Yes.
involve strange decisions by
Hmm.
Mr. Fortuna.
we would like to submit that those strange decisions were firstly made due to performance error, because he's not skilled as a player. He is first time performing on a FIFA level on a competition which is beyond his capacity, and second, he was under immense pressure because he was representing his own country for the first time as a national athlete. I myself, coming from a national athlete background, I can understand the immense pressure you feel when you are on a stage and you are trying to represent your family, your friends, and your country itself. So it is completely.
Were there instances of good play by your client?
There were instances in the first on page 8 of he also saved a goal actually.
That's the 82-43 one, right?
Yes, Prof. 82. Yes, Prof. So he also saved.
Could I just? I know your time's already up, but my last question is: it seemed that suddenly, not suddenly, but when it was clear that his team was already going to lose, his ability to save goals seemed to increase, which some might argue is consistent with match fixing. So, of course, once the fix is in, you're free to save the goal because the team's going to lose anyway, which is what allegedly had been promised. But then earlier, when things were even, he couldn't seem to do anything right.
Right, Professor. So the thing is, in this situation, is that Mr. Fortuna's team only needed 2 goals to move on to the next leg of the competition itself. While we understand that he missed that 1 goal, I would solely attribute that factor due to his skill and also his injury, and also the overall fatigue after the whole 90 minutes match. So while the events surrounding this seems circumstantial and attributable, he was simply just trying to win the game for his country. And while it seems out of place that he only was able to save that last goal at 88 minutes, he was still trying his best to let his country and make his country win. It's just sadly that he was just not able to meet the standard of a good FIFA player.
Okay, thank you.
Thank you very much, Professor.
Good morning, Professor Liu. While the appellant may seek to rely on fairness to govern today's proceedings, the panel must keep in mind that certainty must be kept in balance. This panel has to simply decide.
Sorry, but are you conceding then that fairness cuts in their favor and against your client?
We do understand that fairness does take a big part of today's proceedings, but fairness and certainty must always be kept in
Right, but I
balance.
suppose my question is, are you conceding that fairness on its own would militate against your position? Or because I would have thought your position would be that everything's been perfectly fair. Are you conceding that it's unfair, but the unfairness is outweighed by certainty?
To a certain extent, Professor, but
So what is unfair about this?
unfairness in a sense where the appellant has brought up the case regarding the cyber attack that's prevented them from being able to file a statement of appeal. And to address that issue, I believe that Professor Liu had earlier queried the appellant on what discretion the court might have, and this actually specifically put down in the doctrine of reinstatement, where the CAS has the ability to treat a document that's been filed late as being filed on time. However, we would submit that reinstatement should not be granted in our case because it fills two issues. Firstly, reinstatement can only be granted if the appellant had had filed the statement of appeal, had requested for reinstatement promptly, and on the facts they had not. So
What would be promptly in this situation?
So promptly in the case, as defined in the 2024 case of FC Football and Galatasaray, was when the hindrance that prevented the appellant from submitting the statement of appeal was filed immediately after the hindrance had elapsed. And if I may direct the panel's attention to to Exhibit 9, which is located on the last page of the record. This can be found at page 52. All the way at the end in the text message chain with Mike IT.
52, isn't it 19? This booklet is not paginated. But never mind, I think I have the page. Yes.
Yeah. Thank you, Professor Liu. So at the end, they do note that the incident has now been resolved, and at that juncture of April 26, as noted in the timestamp noted above, the appellant should have immediately requested for reinstatement, noting that the cyber attack could have possibly disrupted their email servers.
So when did they do it instead?
They did it on the 28th of April instead, a solid 2 days after.
Solid 2 days. Look, this is a lawyer's error at best. It's not the client's error. The firm has many things to deal with. Their whole IT system was disrupted. You are a lawyer. Imagine that all the communications across all your files have been disrupted because some malicious third party has attacked your IT provider system. Can you really say that it's an unreasonable delay if on one particular file it takes you 2 days to send the necessary letter or email? This is really harsh.
I understand your concern, Professor Liu, and in this respect, we will turn to our alternative argument which regards the appeal brief, which is a supplementary document to the statement of appeal that must be filed to CAS for an appeal to be considered valid. And with regards to the appeal brief, there was no evidence of such a cyber attack occurring. And the deadline for the appeal brief is 10 days after the expiry of the statement of appeal deadline, which would, as on the case of the appellant, which would have expired on the 3rd of March.
Okay, so where in the record do I find the information relating to the
Appeal brief. With regards to the appeal brief, I will turn the panel's Professor Liu's attention to page 6, para 33.
yes?
On the top line where the appellant had filed the appeal brief before CAS by email and by courier on the 5th of May. However, this is provided by R51 of the CAS code that the appeal brief must be filed 10 days after the expiry of the deadline of the statement of appeal. And in our case, 10 days after 23rd April will be 3rd May. However, they filed the appeal brief 2 days late and without any evidence or explanation for why.
Because the email disruption would not have stopped them from preparing this and filing it.
Indeed,
On the
indeed, Professor Liu, and therefore we are.
Fine. What's the effect of that? Is it provided in the rules that if you don't file your appeal brief, the appeal must be rejected?
While it's not provided in the rules, I will refer the panel's attention to the 2019 CAS decision of Club Sportif Saxon and Jose Paulo, which noted that an appeal brief that has been filed late would render the appeal inadmissible.
Oh, okay.
And unless there are further questions on the first issue, I'll now turn to my second issue. Turning to the second issue, the appellant's refusal in handing over his phone is unlawful for two reasons. Firstly, the duty to collaborate has been breached, and secondly, the ECHR, while applicable to our proceedings, the specific threshold in applying the privilege against self-incrimination has not been met. And I note that Professor Liu had earlier queried where this duty will arise, and this is under Article 12 of the FIDA Disciplinary Code subsection 3, where persons subject to it shall help in particular to provide any evidence as requested by FIFA. And in the present case, if I may direct Professor Liu to page 4, para 20 of the record. Mr. Fortuna had immediately refused to cooperate when FIFA's representative requested that he submit his mobile phone for the purposes of the investigation, which is a clear violation of Article 12, subsection 3 of the FDC.
Does the article require someone to cooperate in whatever way may be demanded? I mean, I know this is the facts here are not so extreme, but imagine it's something like, oh, we demand that you submit the full genetic records of your entire extended family. Like, obviously, that would be going too far, right? So this is not untrammeled, right? And
Yes.
here they're saying, yes, normally my client would have to cooperate, but cooperating in these circumstances would be too great a violation of one, his right to privacy, two, his right against self-incrimination.
Understand, Professor Liu, and in respect to that, we do agree that the duty to collaborate is not an absolute duty, and there are safeguards which has been noted to be applicable in the form of the European Convention of Human Rights, specifically Article 6 and Article 8. However, Article 6, specifically the privilege against self-incrimination, is not applicable in our proceedings today. Noted in the 2017 case decision of Jerome Velk and FIFA, the only situation where this privilege may extend to private investigation is if, and I quote, where there is a clear and imminent danger that a privilege against self-incrimination would be circumvented, and the only scenario where that case recognizes that such a clear and imminent danger would arise if there's an active collaboration between the parties involved and the criminal investigation. And the most crucial fact against the appellant's claim of imminent danger is that the Iridonian Public Prosecutor's Office explicitly refused to share evidence with FIFA, and this is found at page 4, paragraph 15 and 16 of the record, where it was noted that the prosecutor would only share information after their investigation was concluded and the case was ready for court.
Well, that was the position of the prosecutor, but the reverse might not be true. If FIFA became aware of evidence indicating that a criminal offence had been committed, might they not have felt obliged to notify the relevant authorities of that?
Well, in respect of that, we will argue that because based on the facts, there is a clear distinct path that the Iridonian Public Prosecutor is taking and FIFA is taking. Because there's no evidence of active collaboration between the parties, this would negate the claim of a collusive circumvention of Mr. Fortuna's Article 6
I'm still not so
rights.
sure about it, because two things. First, the prosecutor did not say that they wouldn't share. They said they wouldn't share until the criminal investigation was ready to go to the courts. That's not saying we won't share. And as for FIFA made no representation at all as to whether they would share information the other way.
Understand, and actually precisely as Professor Liu has noted, there's no evidence that would go either way, and based on the facts, we would like to take an interpretation that because both parties are not actively collaborating, we will argue that there's no clear and imminent
So this
danger.
is also like a burden thing, right? It's the presumption is that that there isn't an imminent risk. It's
Yeah.
for the appellant to show the imminent risk.
Yes.
Here the evidence is unclear, therefore they fail to show imminent risk.
Precisely, Professor Liu. And to address the Article 8 claim of the right to privacy, it was noted in that same decision that invoking Article 8 will be a fatal blow to the regulatory system of sport, because unlike state authorities, sport governing bodies lack coercive powers and must therefore rely on the mandatory duty of members to provide evidence. And to invoke Article 8 will be a blow to the investigative process. Note that my time is elapsed. If I may have 1 minute to wrap up my submissions on the second issue.
Yes.
And to address the last point, the failure to hand over his phone will result in the consequence of adverse inference, and this is confirmed by the IBA rules, Article 9, subsection 7, where the tribunal may draw inferences that are adverse to the defaulting party.
But it's may draw, right? Not must draw.
Yes, may draw.
So my question then is, why should that inference be drawn when there are other explanations? My understanding of the inference, the way the inference works is, if someone could have produced it and chose not to, then sometimes the inference is that they didn't produce it because it would have been bad for them. But here, even if we agree with you, even if I agree with you that his right to not self-incriminate was not violated,